Imagine you're living in a motorhome. It has a bed, a small kitchen, and everything you need to call it home. One day, while it's parked in a public parking lot, police officers search it without getting a warrant first. Is that legal? That question reached the United States Supreme Court in the case of California versus Carney. Here's what happened. Police in San Diego received information that Charles Carney was involved in illegal drug activity from his motorhome. Officers watched the motorhome while it was parked in a public parking lot. After seeing a visitor enter and leave the vehicle, they stopped the visitor. The visitor admitted that marijuana had been obtained inside the motorhome. With that information, the officers had probable cause to believe there were drugs inside. Instead of getting a search warrant, the officers entered the motorhome immediately. During the search, they found marijuana and arrested Carney. Carney argued that the search violated the Fourth Amendment, which protects people against unreasonable searches and seizures. Welcome to Once Upon a Case, because the law isn't just for lawyers, it's for everyone. He claimed that his motorhome was his home, and homes generally cannot be searched without a warrant unless recognized exception applies. The state of California disagreed. Prosecutors argued that the motorhome was also a vehicle, because it could be driven away at any moment. They said it fell under the automobile exception, which allows police to search a vehicle without a warrant if they have probable cause to believe it contains evidence of a crime. So what did the Supreme Court decide? In a 5-4 decision, the court ruled in favor of California. The court explained that when a motorhome is readily mobile and parked in a public place, it can be treated like a car rather than a house for Fourth Amendment purposes. Since the officers had probable cause to believe the motorhome contained marijuana, they did not need to obtain a search warrant before searching it. The court also explained that vehicles generally have a lower expectation of privacy than traditional homes because they travel on public roads and are subject to government regulations such as licensing and registration. The key takeaway from this case is that not every place someone lives receives the same Fourth Amendment protection as a traditional house. If a motorhome is functioning as a vehicle and is readily mobile, police may search it without a warrant if they have probable cause. The verdict? California won. The Supreme Court held that the warrantless search of Carney's motorhome was constitutional under the automobile exception to the Fourth Amendment. So next time you see an RV, remember this famous legal question: is it a home or is it a vehicle? Thank you for watching. If you enjoyed this story, watch this case next.